Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Hello, lovely people. Another Saturday afternoon is here with us, and we're live on BWTV, bringing you The Community and the Law. Can I apply for my child to join me in the UK if I cannot afford to pay the application fee? Yes? No? Maybe so. We will be looking into that. And this afternoon, we're privileged to have lawyer Eunice Champon, solicitor and a partner of BWF Solicitors, as our guest and resource person. So gather yourselves together, tell the other person to tell the other person that we live on BWTV, at BWF Solicitors, Facebook and YouTube, and at BWF Solicitors. And of course, it's BWTV, both on Facebook and YouTube. Excuse my excitement because I am so happy to have you with us once again. So we are going to get into the discussion, and I believe you have other questions and concerns you want to bring up. Lawyer Eunice Champon will be gracious enough to let us in with answers, solutions, and suggestions. My name is Oreku Frimpong. Good afternoon and welcome to The Community and the Law, brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Another hearty welcome to all of you. We're live on BWTV, bringing you the community and the law, brought to you by BWF Solicitors. We've gone through another week. Here in the UK, it's been grey, wet, and windy, and people are saying, well, the weather has been bad. But you know what? I'm bringing some sunshine into your life this afternoon because I'm bringing you the answer to a very big question you have been thinking about all throughout. Can you apply for your child to join you in the UK if you cannot afford to pay the application fees? Lawyer Eunice Champong, our guest and resource person, is a solicitor and a partner of BWF Solicitors. And this afternoon, she's going to help us get into this, unravel the mystery, and of course, proffer some solutions and suggestions as to how we can go about this when it comes to immigration matters here in the UK. Lawyer Eunice, good afternoon.
Good afternoon, Oreku. I hope by God's grace you're doing well.
I am very well by God's grace. Everybody in the family is fine, and I believe you're doing well as well.
Yes, I am.
Okay.
I'm doing very, very well.
Um, this afternoon we've come again as usual, and we want you to help us answer that question. Even though you're not going to do that, but I believe you are ready to help us in on whether we could apply for our children to join us in the UK if we cannot afford to pay the application fees. We're ready for you because it's a big question.
Yes, it's definitely one of those questions that those, especially who are mothers who want to bring their children over to the UK, have been asking. I emphasize mothers because they are usually the ones who are the home carers, and they are the ones that look after the children. And so um, they have it on their mind when the children are not all together. And when, for instance, they've had children here in the UK and then there are some back home, they are always thinking, when would my child or my children come and join me so that we can be one family? And so, yes, a lot of this will be on the basis of those parents or mothers who would want their children to join them here in the UK, and then there might be some difficulties affording the fees if they were to make those applications. So yes, it's a big question on their minds, and we want to delve into it this evening.
Yes, so definitely, if you just joined us, we'll be talking money, affordability, family issues, and of course, your application. So get your questions ready, get them packed up, so to speak. Lawyer Eunice will help us do that. But before then, let's say thank you to BWF Solicitors. And we are going to do that, one, as clients, two, as a member of the family. I'm going to lead us to welcome one of our very own who has just joined the team. And we want to do that as the family does every time. But before then, Mami Adjoa says, Uncle Ben and his team are the creme de la creme of everything law, especially immigration. Will I engage them again? Yes. Thanks to Uncle Ben and Abigail for helping me with my indefinite leave to remain application U. are the best. That's one term that I really love. Creme de la creme, the best of the best. Agni Eunice,
Yes.
that's your new accolade.
Thank you so much. And yes, I believe that Mami Ajwa is truly satisfied. You know, when you come to the completion of your settlement here in the UK, there is this sense of excitement, of accomplishment that now you feel like you don't have to keep battling, or you don't have these challenges to go through again and again. And I think because she has reached the end of her journey in terms of her immigration status, she's obviously excited, and we are pleased for her. And like she said, she is ready to engage us at any point in time for any other issues, or even if it's to do with naturalization. I'm sure she would obviously come back for us to service her again. So we really appreciate you, Mami Ajwa, and we hope that you do recommend others as well.
There is a lot of hope when you deal with BWF solicitors. I'm going to say this and I'll say it again because I've been reiterating it. Visit us on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. It's the only Ghanaian legal firm that supplies with the Golden Tree chocolate. So come in. If you come in and you're not given a bar, come back. I'll pay you. In any case, well, the welcome is so Ghanaian, so nice. Well, I said I was going to welcome one of our very own who's just joined us. We have Lena Asma joining us as a paralegal here at BWF Solicitors. So that's an addition to the team, one of the very sharp brains when it comes to legal matters. Has joined the team, and Lena is with us here. Auntie Eunice, what do we expect?
Yes, so we welcome Helena to the team. She's previously trained as a barrister in Ghana, and so she is a qualified barrister in Ghana, and she's also done her LPC here, or should I say, she's completing her SQE, which is the solicitor's qualification exams here in the UK. She's already done her degree and master's here in the UK as well. And so she's coming on board with a lot of experience from Ghana, and also a lot of knowledge and understanding of the UK law as well. And so we welcome her to the team, and we are hoping that she will definitely be one of the best solicitors, upcoming solicitors, and hopefully by the time she's qualified, we would know who Helena Asma truly is. But we are so happy to have her on board, and we want her to enjoy her, should I say, her few moments here where she's obviously training, and then we hope to see her qualified and be one of the best that she will be. We're hoping that she will be in the coming years. And so, yes, we are expecting great things from Helena.
Well, maybe I'll be the next person you guys have to train. So, is there an opportunity for people to come in to get their training from BWF solicitors?
Oh, definitely. There are opportunities when it comes to obviously those who are doing their SQE. So because I'm part of the old batch, I know the introduction of the SQE in recent years means that you get to do the professional course, but then you get to also train with different law firms in regards to your qualification. And so once you have obviously completed your degree or your master's, and you are looking to qualify as a solicitor, you then have to embark on the SQE, which is the solicitor's qualification exams. So it's part exams and then part training.
Mm.
Once you have gone through the examinations, you can then train with any law firm of your choice. It could be one law firm, it could be two law firms, but at least you have to complete that training period. And we at BWS Solicitors, where there is that vacancy, we definitely offer training to those who are willing. And obviously, a lot of the people that you have seen, a lot of the lawyers that we have trained are those that came through the LPC route or the SQE route and have fully qualified as well as solicitors. And so our principal, Mr. Bernardo, also believes very much in taking on the younger ones and training them and making them the best that they can be in the field of work that we obviously are experts in.
All right. So welcome, Lena. Welcome on board. And definitely, I know, as Lawyer Eunice has said, people have the benefit of your expertise and skills and knowledge from Ghana and here in the UK as well. Thank you very much. And as an update, I posed the question, and I think earlier in the week, the principal, Uncle Ben, had a discussion on that on this platform. The question was: is your customary marriage in Ghana recognized in the UK? We're looking at a case, Auku versus Secretary of State for the Home Department, 2017 case, England and Wales Court of Appeal case 178. Now, it says your customary marriage contracted in Ghana through family members, that is proxies, is valid under the UK law if it followed Ghanaian law and procedure. The case of Awuku versus Secretary of State for the Home Department is a landmark decision in UK immigration law. The judgment that we're talking about established that a proxy marriage performed in a third country, such as Ghana, is valid in the UK if it is recognized by the law of the country where it took place, ex loci celebrations. What we advise is always follow Ghanaian law by asking family members to register the marriage at the marriage registry or the Metropolitan or District Assembly. Then, when you've done that, the advice is contact us if you have issues with the Ghanaian customary marriage. Well, is a reiteration of what actually should be existing already. But Linus, even though people have had the chance to listen to Uncle Ben, let me ask this question and say, why would the Home Office say that marriages in Ghana may not be valid and recognized here in the UK? What happened, and has this clarified the situation?
I think when it comes to marriages in the Western world, a lot of the marriages that take place are performed by the couple themselves. And so, if I choose to get married, for instance, the ceremony would take place with me and my husband being present, and we will have our guest and everybody else present. And so, the idea that a marriage ceremony can go on without the couple is something that is also foreign, and therefore they believe that if that is how marriage is conducted in a foreign country, as long as it is seen to be legal and is done competently, then obviously they would also recognize it in the UK. And so a proxy marriage or a marriage conducted by family members of the couple, which in Ghana we choose to call customary marriage, those marriages are also seen to be valid under our Ghanaian PMDC law. And so there's no obligation for anybody to register their customary marriage. But a lot of the time, because it is used here in the UK, we advise people to register those marriages. And it's traditional in especially the Akan culture for the man to go to the woman's family and ask for her hand in marriage. And then they also will give their consent in terms of what they would want to be brought in terms of dowry. And then they take the consent of their daughter and say, okay, if you have chosen to marry this person, then we also agree to your decision. And so, as long as both parties have agreed and consented to the marriage taking place, the family members can go ahead and perform the ceremony without the couple being present at the ceremony.
Right. So, as it has, somebody had challenged that, and the ruling is that the customary marriage contracted in Ghana through family members, that is, proxy married, is valid under UK law if it followed the Ghanaian law and procedure. Thank you very much, Lawyer Eunice. There's another one that BWF put out for us to take note of, and it's a nugget for this week. And it talks about relationship with partners and how it is looked at under the law. And it says under the immigration rules, one of the requirements for a spousal visa is the validity of the relationship, where the relationship is based on marriage. The rules stipulate that if an applicant and the partner are married or in a civil partnership, that marriage or civil partnership must be recognized by law in the country in which it took place. It looks like it follows on from there. Can you further throw light on this one for us, please, Laura Eunice?
Yes, so I think in this context, we are referring particularly to appendix relationship with partner, and that partner appendix is usually used for most applications where you are relying on a partner. And so it stipulates, as it says in the nuggets, that any marriage which has taken place in a foreign country has to meet the requirements of that country in order for it to be recognized here in the UK. And so, if it is a genuine marriage, then they expect that all the procedures in place in that country would have taken place before a registration certificate, for instance, is shown here in the UK. And so you would see, particularly in that appendix, that you will have to show evidence of your marriage. And one way of showing evidence of your marriage is through your marriage certificate. And in the case of those who have undergone a customary marriage, you would see that the customary marriage certificate will come with a statutory declaration which shows that all the rites have been performed and the family members and the couple have consented to the marriage taking place. It will show their habitual place of residence as a couple and then where the marriage also took place. The family members who stood in for the couple and were present will also be stated on the statutory declaration. And then another way to make sure that the document that you're presenting is from a competent authority. You would have an attestation from the Judicial Service in Ghana. You will also have an attestation from the Foreign Affairs Ministry as well in Ghana. And then the Municipal Assembly or the registration um, place where the marriage took place will also put an attestation letter to the statutory declaration and the customary marriage certificate in order for the couple here in the UK to use it as evidence that the marriage did take place in a foreign country and all the requirements have been met because the competent authorities have, should I say, rubber stamped the certificate. So once it's gone through that process, you know that you have a genuine marriage certificate to present. And we always advise that once it comes here to the UK, you can also get an attestation from the Ghana High Commission as well.
Right. Now, the attestation from the Ghana High Commission, for instance, is it something that will make it more legitimate, or if you don't have it, it could be okay?
Usually, the attestation from the Ghana High Commission just confirms the competent authorities that have attested to the marriage beforehand. Usually, we ask for that to be done so that the caseworker who is not familiar with such a document will know that even though this is a foreign document, the embassy here in the UK have gone ahead to also vet for you that the competent authorities have done what they should do in terms of verifying the document. And so it helps the caseworker know that the documentation that you have brought forward to them has been verified and attested, and at least they are able to move smoothly with that. Most of the time, I know that some people may bring documents from a country where the language is different, and where the language is different, they'll ask for it to be translated, but in our case it's always done in English. And so there is nothing wrong with us translating our documents, but it also helps when you have a competent authority in the UK verifying the documents that have come from a foreign country, so that at least they know that the due process has been done in that country.
Well, then I am going to, Loines, present this scenario and see if I could give some advice here and there. Mary and Joseph married in Ghana in June 2025. They registered their marriage in court and were issued with the Ghanaian Ordinance Marriage Certificate dated the 20th of June 2025. Mary could not travel to Ghana for her wedding, and so she was represented by her uncle at the marriage registration. On the 15th of January 2026, Joseph submitted a visa application to join his wife, Mary, in the UK. Now, on the 30th of January, Joseph received a refusal decision from the Home Office. The only reason for the refusal is that his marriage is not valid because Joseph was not present during the marriage. So, can I advise Joseph that he should appeal because the caseworker did not apply the rules correctly? Or can I say to Joseph that he should not appeal because the caseworker applied the rules correctly? Um, you know what? I'll leave this and try it with viewers first before I come back to you, Laura Innes, if that's okay.
Yes.
Okay. All right. So yeah, those of you out there watching and listening to us, try your hands on this. Look at Joseph and Mary's situation, and then give me the correct answer. This time I've given you only two, so it's either A or B. It's either one or two. You don't have to be guessing around too much. But consider the nugget, the explanation Lawyer Eunice is giving, and give me an advice to be given to Joseph. I'll pick that one up later on in the program. And whilst we go on and we're going to move on to our main discussion, I want to recognize those of you who have joined us. And remember, we're going to look at the question, can I apply for my child to join me in the UK if I cannot afford to pay the application fee? So those of you who have joined us and watching with us, thank you so very much. Make your presence felt and leave a comment in the comment section down below, or send me a text or WhatsApp 0739920848. Mami Efua Osaki, thank you very much for joining. Gomez, you are watching with us. We have Kobe Pop Fanus. You are watching with us. Jenny Miracle, you are here. I have Frank Minaba Akon, Emmanuel Anyande, Adai Safo is on, and Adai, thank you very much. You wished us all good afternoon. We have George Wash, then Obiodon Ojo. You are also there with us. Engineer Samuel Mensah. Joseph should appeal for that decision. Well, Joseph, I'll pick this one up again later on. Okay, that's fine. Thank you for attempting it. I think you're trying to be quite smart and quick about it. Thank you so very much. We have, let me see. Okay, Jenny Miracle, I've mentioned you. So if you are here, let us see what you have said and let us feel your presence as well. But in the meantime, thank you very much for joining us. It's a community and the law, and brought to you by BWF Solicitors, our trusted partners when it comes to the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. Yes, now, without further ado, let's go to see if we can get our question answered. Can I apply for my child to join me in the UK if I cannot afford the application fee? Cannot afford to pay the application fee. I know several people find themselves in a situation like that. People get to the reality of the situation when it is that it's time for you to apply for a situation, a visa, extending, applying for a new one, or whatever it is, then you are hit with those thousands of pounds. But if you cannot afford, what you do, you would have to definitely regularize your stay here in the UK. And we're talking family as well. Our children would have to join us. We want our children to come in so that we can maintain the family relationship and all the rest of it. So if I cannot afford, should my child stay so far away from me forever or what? Lioness, application fees. A very straightforward question. You are not the Home Office, but let me ask, why is it that it's a problem and people cannot afford? It's too expensive.
Yes, I think when it comes to home office application fees, they keep increasing over the years. And I remember one person said to me, when I first came to the UK, the application fee was just over £600. Now it's over 1,000 plus, and you have the extra charge of the immigration help surcharge. And so, obviously, since the Immigration Act of 2014, every application you make, apart from indefinite leave to remain applications, will carry an immigration help surcharge. And that is charged at £1,035 per year for adults, and then at £776 per year for children. And so if you are including the immigration health surcharge to the application fee, it seems like a whole lot depending on the number of years that will be granted to the child or the adult. And so it makes it very, very expensive, and therefore that is why some parents are unable to afford the fees, especially if you are making an application from outside the UK.
Mhm.
That carries a lot more should I say, weight in terms of the fees. And so you're looking about almost £2,000 for the application itself, and then the IHS as well is £776 per year. So if they're going to give that child 1 year's visa or 2 year or 2.5 year visa, you multiply by the number of years that that
Mhm.
child will be granted, and then you know that you're not paying a small amount of fees. And so I believe, obviously, the Home Office know that not everybody would be able to afford the fees when it comes to making these sort of applications as well. And also, the number of children that you may be applying for will mean that the fees will go higher. And
Mm.
so, these are things that they have to bear in mind when someone is making such an application.
Is there any consideration for, say, you have more than two children or a higher number of children, and then it becomes quite exorbitant? Is there any
Mm.
consideration the Home Office is giving so that maybe there will be a discount or a cap as to how much you can pay?
Well, with children, the only discount they have is the fact that their IHS fees is different to the adult. The application fee stands the same
Mhm.
with both children and adults, but the IHS, which is the immigration health surcharge, that is discounted at a rate of £776 per year, whereas the adults will have to pay £1,035 per year. So that's the only discount that they offer to children. And even if you have 10 children, they will still have to pay that £776 per year.
Is it laid in stone that if you can't, forget? If you can't afford it, are they saying forget about it because that's the rule, that's the law? This is how much we charge. If you want your children to join you, pay it. If you can't pay, forget it. Is that what they are saying?
I mean, at first, that was how it seemed because there wasn't a fee waiver option for entry clearance applications. So in the, should I say, 2012 and onwards, up until I would say around 2020, when they introduced fee waiver for entry clearance applications, you would have had to pay the home office fees and the immigration health surcharge. And so it was those that could afford to pay those fees, they are the ones who would usually have made an application. And you could see that a lot of parents would take such a long time to make those applications for their children because they really couldn't afford it. They have mouths to feed here in the UK, they have bills to pay, and there was no way they could now pay for another child to come and join them. And so they would have been here for years, but they wouldn't be able to make that application for the child to join them or even go and visit the child because they had to try and save something or put something aside to be able to bring that child over. But we thank God that obviously the rules have changed and they've made it possible for parents to now apply for a fee waiver, in addition to the fee waivers that we do in country. They can now do those fee waivers out of country in order to have the Home Office waive the Home Office fees and the immigration health surcharge in such applications.
Yeah, so if you are here and you want to apply for children outside of the UK, previously you couldn't. Now you could apply for a fee waiver and prove that you can't afford it. So then they can take the fee away for you. But if they do, would you still have to pay the health surcharge?
It has to be based on the assessment they make. So if they believe that you cannot afford both the application fee and the IHS, then you would have both waived off for you.
How easy is that? How can I prove and
Mm.
convince them that I can't afford the fee? How do I do it?
Okay, so let's explain it from how the caseworker will assess your documentation or your evidence. So with every application that is made, the Home Office has its own guidance that they look to in terms of deciding who is allowed a fee waiver and who is not. And we have case law that also sets precedence in terms of these decisions. So in 2012, we had the case of Omar, where the court said that in such an application for asylum, where the applicants did not have any means of paying the fees, if the applicant was destitute, then it was the case of the caseworker to make sure that they waive the fees so that the applicant is able to make such an application because it was based on their human rights. So most applications would be based on families coming together. And we know from Article 8 that the right to family life and private life is very important and is upheld by signatories to the ECHR, which is the European Convention of Human Rights. And therefore, the UK being a signatory also upholds that right for its people and those coming into the UK as well. So we know from the case of Omar that if there is a case where the person is destitute, they have to forego the fee. And then we had the case of Carter in 2014, where they looked at the fact that if the person were to pay those fees, it is likely that they will become destitute, or there may be some compelling and compassionate circumstances which would require the Home Office to waive their fees in such an application. And then they brought the test further down in 2020 when we had the case of Zineku Lijeson and her family. Yes, they were being financially supported by friends and family. However, they could not pay for their home office fees because they had five kids. So, her partner, and these five children, there was no way they could afford to pay the home office fees in regards to this human rights application. And so the test was if they could not afford the fees, they shouldn't pay those fees to the Home Office. And therefore, the Home Office had to waive the fees on behalf of the family. So, if there are cases where there's a human rights application being made and the person is destitute, or the person is likely to be destitute and cannot afford their essential needs, or there are compelling and compassionate grounds. And then the final test is where they cannot afford the fees at all. Then the Home Office has to waive the fees for such an application. And so the same principle applies if you are making an application for your child to join you, where as a parent you are making a human rights application. And I must emphasize that it does not apply to indefinite leave to remain applications because those are not seen to be human rights applications. Where you are applying for indefinite leave to remain, it is a settlement application, which means that you are applying to come and settle or make the UK your permanent home. And therefore, those applications are not seen to be human rights applications. And in such a case, you would have to pay for the application fee, but there will be no immigration health surcharge because they don't charge immigration health surcharges with settlement applications or with indefinite leave to remain applications. But where you're applying for the child to come here on a leave to remain basis, then you can apply for a fee waiver on that basis, and then the caseworker will have to look at those tests. And if it is only on the basis of even one of those tests that I've mentioned, For instance, where you cannot afford the fees, they've looked at your bank accounts, they've looked at your expenses, and they've realized that you simply do not have that money in your account to pay, then it makes sense for them to waive the fee. Because even if you were to try and save, there will be nothing to save, or there'll be nothing to put down every month in order to pay the home office fees. And therefore, due to the fact that you cannot afford the fees, they have to waive it for the child or for the children that you would like to bring to the UK.
Now, Linus, if I put in an application for fee waiver, how long does it take for a response to be given? And then again, if I put in an application for fee waiver and it's not responded to, does it hold any other situation? Or let me even put it this way, does Section 3C kick in that situation?
Okay, so with fee waiver applications, because it's a request to the Home Office to waive that fee, usually most people will be doing that um, initially if they are bringing the child to come and live here in the UK. And
Mhm.
because that child has never had leave to remain before, a Section 3C cannot apply because they've never
Okay.
had leave to remain before. And so, because it's their first application, most of the time, if you are applying for the Home Office to waive the fee, it can take up at least 6 months for them to respond to
You said
such.
at least 6 months.
Yes.
So it could be a year, it could be 24 months.
It it could be more than 6 months, basically.
Yeah.
So yes, usually if you're making a fee waiver application, it does take some time. It's always good if you have a legal representative doing that application so that they can
Mhm.
obviously find out with the Home Office if they need further documents or anything else in regards to such a request. Obviously they have to decide on that application and then give you a response in order to be able to make the human rights application. So if you cannot afford the fees, then you would just have to wait for them to respond before you can make the application for their leave to remain.
So when they haven't made a decision, so to speak, and you are waiting, can you withdraw that application if, in any case, your circumstances change? For instance, now it's been with them for 6 months. Within the 6 months, or probably beyond the 6 months, your situation has changed. You want your children to come to join you quite quickly. Can you withdraw that application?
Of course, I mean, there are situations where, for instance, the person who is the parent applying for this fee waiver may have friends or family who are able to support. And so, in the case where a friend or a family member is saying, "Hey, I have the money, I can give you the money to apply for your child or for your children to come and join you." So, just withdraw the fee waiver request and let's pay for it so that they can come as soon as possible. Of course, you can let the Home Office know that you want to withdraw the fee waiver request and make the application directly. And once, of course, you have the fees readily available, you can make the application and pay for it as soon as possible, especially when it comes to children who will be turning 18 very shortly. It makes more sense to make the application as soon as possible rather than to wait for a fee waiver decision, which is not coming, or which is taking longer than usual to be decided. So, yes, in cases where the circumstances have changed, you can definitely withdraw your fee waiver request.
We know that when it comes to fee waiver applications, especially when you are doing an in-country one, either renewing your existing stay, when it's granted, or denied, you have a certain number of days to apply after that. That situation, does it apply to the one that is being done out of country?
So yes, I think you're referring to the 10 days
Mhm.
period that you have when you have made the fee waiver request and a decision has come. It's the same for entry clearance applications or for applications where the family member is joining you. So if a fee waiver request is put in and a decision has been made, they would usually give you a period of 10 working days to put in the actual application. And so whether they refuse or they allow your fee waiver request, you have 10 working days in which you can make the application for that child to come and join you here in the UK. So, yes, the 10 days apply.
So, in a situation of where you're applying for entry clearance, um, the fee waiver application, let's say in the unwanted situation where it's denied, why would they insist that you apply in 10 working days? Maybe you would want to sit back and organize yourself to get the resources to pay. Why would they compel me to do that application within 10 working days?
So, under our immigration rules, we have rules that state or stipulate under our paragraph 39J. It talks about the fact that when you make a fee waiver application, the grace period that you have after a fee waiver application is to have it completed within 10 working days. And I think it also serves you notice once that fee waiver request has decision has been made that you are to also fulfill your side of the bargain. And
Mhm.
so they expect that now that that decision has been made, you will not take a longer period of time to put in the application, especially if they've granted you the fee waiver. They would expect that you put in that application as soon as possible because it's on their basis that they have granted you the waiver. And so, as much as possible, they want you to take hold of that privilege that you've been given and make the application as soon as possible. Where you've been refused, I know the 10 days still apply, but in that case, it makes it very difficult for the person who is applying on behalf of the child to find the fees because obviously it would seem like they took such a long time to make a decision. So why can't I also take a long time to also decide when I can pay for it? In cases like this, because there's no leave to remain, if you can't gather the money within the 10 days, I would say take your time and try and gather the money. Obviously, if there were Section 3C or a leave to remain in question, then you would need to find that money as soon as possible. But in this case, there's never been a leave to remain. There isn't any Section 3C hanging over your head. So if it's going to take you longer to gather the money and then bring the child over, then take your time, gather the money, and then do the application. But also remember that when the child turns 18, it becomes a different ball game because they will no longer be seen as a child under the immigration rules.
Well, if you just joined us, we're live on BWTV and we're doing this Kesty. BWF solicitors are trusted partners when it comes to the law. BWF solicitors deals in immigration matters, family matters, legal issues where we give you advice and updates from the Home Office, as well as help you with some business ideas. BWF solicitors, you can call them on 0208 493 7340 In emergency situations, you can call 077 127 61884 077 127 61884. Those of you in Ghana, there's an office, and you can reach us on 055 589 5959 055 589 5959. BWF Solicitors are trusted partners when it comes to the law. Here in the UK, they're located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. The postcode is N154NP. If you come by train, jump onto the Victoria line from wherever you are and get off at Seven Sisters. Use exit number 2, and that will bring you to the frontage of the Anna House. Climb to the fourth floor, Monday to Friday between 9:30 in the morning and 6 p.m. BWF Solicitor brings you the community and the law live on BWTV, and you can get us on Facebook and YouTube at BWF Solicitors and at BWTV UK. We'll be right back to continue the discussion. This afternoon, we are looking at whether we can apply for our children to join us in the UK if we cannot afford to pay the application fee. Our resource person and guest is a partner of BWF Solicitors, the solicitor, lawyer Eunice Achampo. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And I'm so glad to have you still around. In the comment section down below, I've seen that some questions have popped up. I've seen that people are announcing themselves and people calling and inviting people to do that. So yes, when you join us, like the page, pick up the link and share. and also encourage people to really subscribe to the channel. It's BWTV UK and BWF Solicitors. Isaac Frimpong, thank you for joining. God bless, and we appreciate your time with us. Citizen Kwajo Kwache Pepra Alex. We have Jenny Miracle, I mentioned before, Maminyako Abronuma, you're watching. Mumin Abubakar, you are also with us. Douglas Asafweji, I've seen you and you're watching with that. Bernard Fosu, you're also watching with us. So keep your comments, your questions coming through. Now I'm going to activate the lines 0208 493 7345. 0208 493 7345. You can join us. Lawyer Eunice Champon is still here and she will help us with that. If you have a text, WhatsApp, or a voice note, send it to 07399 208 468. 07399 208 468. Lawyer, let me quickly touch on this one before we pick up any of the comments and the concerns that have come through. Now, you have made it clear to us now that it is possible for people to apply for fee waiver if they are applying for entry clearance for their children to join them. The question I'm asking is, once this opportunity is there, what do I need to prove with my statements, with my bank accounts, and any other evidence? What do I need to do? What needs to go in there? What do I need to show?
So, if you look critically at the guidance that the Home Office have on fee waiver, it explains that the caseworker is to look at your evidence for income or your evidence for earnings and your expenses as well. And so, anything that shows your income, it could be your bank statements, it could be pay slips from your job, it could be evidence of rent payments from people who are living in a house that you have. So anything that shows your income um, is something that you should prove to them. So if you're sending your bank statements, usually they require your 6 months bank statements, which is the most recent 6 months. And then if you're working, evidence of your pay slips should be shown. If you are somebody who is also self employed, then you definitely need evidence of your self assessment and tax paid and bank statements for 12 months. So it's different for somebody who is employed and somebody who is self employed. If you are showing evidence of your expenses, you definitely have to show that you are paying your rent, your um, what do you call it, bills, and other outgoings. There are some who have loans that they are repaying. There are those who also have, should I say, credit cards that they are also paying off. And so, any form of expense that you are paying apart from your bills, you need to show evidence of that. And that could be your utility bills, your credit card payments, your loans that you're paying off. Any form of expense should also be shown so that they know what the money is being used for. But they ask that you annotate your bank statements for every amount over £250, just so that they know what the money is being used for. So if there is any outgoings from your account which is showing £250 or more, then they expect that you would explain to them what that money was used for in order for them to assess whether you would still be eligible for a fee waiver request or not. And so any evidence showing your income and your expenses is what is needed for them to make their decision in terms of your application. And if there's anybody who is sick as well, especially because there might be children in the family who may be sick and therefore maybe the parent is not working. And so if due to an illness or a disability, the parent is not working, please provide evidence of the disability or the illness so that they can also know the circumstances surrounding your application.
You mentioned the annotation of amounts 250 and above. That's the outgoings. But
Mm.
if I am to receive something 250 and above, do I have to still annotate that as well?
So if it's a regular payment, for instance, it's a family um, person supporting you, once you have stated categorically that you are not working, and so it is this particular family friend who is supporting you,
Mhm.
then they will know from the first annotation that this family friend is the one who is giving you that financial support. So you don't have to keep, should I say, annotating that incoming amount all the time. So in terms of income, if the income is from a particular source which is regular, then just stating it clearly that this is your only income, for instance, will alert them and let them know that this is the only income you're receiving. Unless it's from different sources, then of course you would have to state what the income is for.
So on the form that I will complete, if I have extra information to give the Home Office, explaining what each either expenditure line or income line is, can I add extra sheets of paper so I can be very detailed and tell them, listen, I can't afford, and these are the reasons why? Can I add extra information?
They always have a section where it says further information.
Mhm.
Obviously, you can put in there that these are extra expenses or extra income that you were not able to put on the actual application, but
Mhm.
you are explaining that this is what you received through your bank account and this is what you are able to show in terms of your expenses. And of course, they will have a look at it. Once you've even completed the online form, there is always a link that is sent for you to submit your documents. So you can also add a cover letter which has a list of your income and a list of your expenses so that it's clear to the caseworker what your income is and how much is used on expenses. Some people might be receiving maybe £200 a month, but their expenses are way more than the income they are receiving. And so it's important that you list it clearly for the caseworker to know so that they can make a decision in accordance with the fact that you are not able to afford the fee.
Well, folks, Lawyer Yunusan Champon has really helped us with explanations, and I believe I've asked so many questions that were on your mind. But there may be other questions that you want to pose. So, as I mentioned earlier on, the lines are active 073 okay, sorry. I was giving a signal, so I thought I was doing the wrong thing. 0208 493 7345. The lines are active. Or you can send a text or WhatsApp to 07399208468. And we will get Lawyer Eunice to answer your questions for you. Remember, I posed a question with what we discussed in the segment where we had a nugget. And what we said was that under the UK immigration rules, one of the requirements for a spousal visa is the validity of the relationship. When the relationship is based on marriage, the rules stipulate that if an applicant and the partner are married in a civil partnership or in a civil partnership, that marriage or civil partnership must be recognized by law in the country in which it took place. That's from paragraph RWP 4.1 of Appendix Relationship with Partner. So that said, and the explanation given, I asked the question about Mary and Joseph, who married in Ghana in June 2025. They registered their marriage in court and they were issued with a Ghanaian ordinance marriage certificate dated the 20th of June 2025. Mary could not travel to Ghana for her wedding, and so she was represented by her uncle at the marriage registration. Down the line, on the 15th of January 2026, Joseph submitted a visa application to join his wife Mary in the UK. On 30th January 2026, he received a refusal decision from the Home Office. The only reason for the refusal was that his marriage was not valid because Joseph was not present at the marriage. What advice do you think I should give to Joseph? Should I say to him that he should appeal because the case worker did not apply the rules correctly? Should I say to him that he should not appeal because the caseworker applied the rules correctly? Okay, well, think about that. I know it's just two answers, so going to be an easy peasy thing. But when we come back later on, I would see which one would be the correct one, and lawyer Eunice Champon will help us with that. Remember, we're doing this by courtesy of BWF Solicitors. Now, let's pick your questions and comments there and get lawyer Eunice to help us with that. I stand to be corrected if I'm wrong regarding the number of absent days on the 10-year route. This is Citizen Kweju. He says that his understanding is that at any point during the 10-year qualifying period, one must not have spent more than 180 days outside the UK in every 12 months within the 10 years. Does this limit reset when you renew or extend your visa? Please, what's the maximum total number of absence days allowed overall across the 10-year route? Lawyer.
Okay, so Citizen Kwejo, yes, you are right. Under Appendix Continuous Residence, you do have to show that you have not been absent for a period of 180 days over a 12-month period. So if for any reason you have been absent for more than 180 days within a 12-month period, I know he's asking whether it resets once you've made an application. If for any reason, of course, you've been absent for that 180 days, which is, let's say, 182 days within a 1 year period, and then you are saying, oh my goodness, because I've been absent for 182 days, if I make the application for indefinite leave to remain, it's going to be looked at as spending more than the time I was allowed. And therefore, it may mean that you might have to count the 10 years from when you spent less time um, outside of the UK. So, if, for example, in 2022, you were out of the country for more than 180 days, and you know that your 10 years is going to be up, let's say in 2026, and you're looking to make the application for indefinite leave to remain, if you have good reason for why you had to spend more than the 180 days outside of the UK, then the caseworker is ready to look at the reasonable excuse that you have in terms of the 182 days that you spent outside the UK. If there are no reasonable reasons why you spent 182 days outside, then it means that you're counting from the time you came back, which was in 2022, there onwards. And so it's important that you take note of your absences whilst abroad or whilst outside the UK so that it doesn't affect your leave when you are making the indefinite leave to remain application. And those who come under this usually are those who are obviously on the 10-year route. And so it's very, very important that when you're looking at applying for settlement or for indefinite leave to remain, that your period of absences are very minimal.
Okay. All right, Citizen Kojo, thank you very much. Let's pick up the next one here that we have from the platform. Lady Prissy is asking, lawyer, um, if I hold the EU passport, do I need to get the certificate of entitlement? If yes, how do I apply?
No, so EU nationals are not British nationals. So if you hold an EU passport, they have said that you either have to apply to the EU settlement scheme, or if you are from the EU coming to visit the UK, you need to apply for an electronic travel authorization. So once you've applied for an electronic travel authorization, it's usually valid for 2 years, and you can come in and out of the UK within that 2 years.
Okay. All right. So, Lady Prissy, that's the explanation for you. Thank you very much for your time. Um, I'm writing to urgently request legal representation for my asylum case. I am an Iranian national currently accommodated at the Westerfield site, CM7. I'm contacting your firm because I've been unable to find a local solicitor in excess with the capacity to take on my case. My asylum interview is scheduled for February 16th, and I require legal assistance as soon as possible. These are the details. Legal aid, I'm receiving Section 95 support, and I'm eligible for legal aid. I require a Kurdish Surani interpreter for all consultations. My home office reference is stated. Although I'm in Essex, I'm happy to correspond via telephone or video link if your friend can represent me remotely. Could you please let me know if you have the capacity to take on a new legal aid asylum case? I look forward to your urgent request, and his name is down there. Lawyer.
So yes, Mr. Ash Dustum, when it comes to legal aid, not all law firms are subscribed to the Legal Aid Authority. So BWF, unfortunately, is also not one of the law firms that is signatory to the Legal Aid Authority, and so we do not offer legal aid. If you are to find a legal aid firm, then I would suggest that you go onto the Law Society website and you type in your area and the fact that you are specifically looking for a legal aid representative, and it should bring up the legal aid firms in your area or in your county that you can obviously contact to represent you in your matter. So, yes, please go onto the Law Society website, and that hopefully should help you out in terms of finding a legal aid representative.
All right, my dear friend, yes, that's the advice given. Thank you very much. We pick up the next one, and remember the lines are still active: 0208 493 7345. How much cost for child application outside the UK and the health surcharge?
Okay, so I'm guessing this is relation to our topic for
I
today.
guess so.
Usually, the application fee is just about £2,000, and then the immigration health surcharge, like I said, is £776 per year. Usually, if a child is being granted leave to remain, they'll be granted the same leave in accordance with the parents' leave. So if the parents has 2.5 years leave and they've spent a year and is left with a year and a half on their leave, they will grant the child a year and a half. And so if the child is supposed to pay immigration health surcharge for 1 year and a half, you are looking at just about £1,500 for the year and a half, and then they have to pay the application fee, which is also £2,000. So if you put it all together, it's over £3,000. Yeah.
Well, Andrew, thank you for your contribution and thank you for sticking around with us. We'll move on to the next one, which is from Berma Yao. If you have a visitor's visa in your passport, do you still need an e visa when you want to visit the UK?
No, so those on visitors visa usually, I know even if you come with a, a visit visa which is valid for 5 years, you still have to stay for a period of 6 months and then return to your country of origin. So with that period of 6 months, they don't have an e visa, and so they know that those who come in with a short term visa or a visit visa would not have access to e visas. And so they do not require them to have e visas. They can come in with the vignettes in their passports.
Mayao, thank you very much. That's your answer from lawyer Eunice. The next one is from um, Alphonse Tete. Now, Alphonse says, if my indefinite leave to remain under the EU settlement scheme, I have my indefinite leave to remain under the EU settlement scheme, and I've been in the UK for the past 2.5 years. Can I apply for citizenship?
Yes, so if you have indefinite leave to remain and you can show that, of course, for the last 12 months, and in his case, he's been here obviously more than 12 months, he can show that for the last 12 months he's had indefinite leave to remain, which is no restrictions on his leave in the UK. And he can show that he has resided in the UK for a continuous period of 5 years lawfully. So he has to show that he's been also lawful residing in the UK for that period of 5 years, in addition to the 2 years in which he was already here. Then he can make the application for naturalization. He would have to complete the Life in the UK test and the English language test at level B1 if he hasn't got an undergraduate or master's degree.
Alphonse, that's your answer. Thank you. We go to the next one, and it's coming from Okatechi Papa Kwame. Now, Katechi is asking, Laura, can EU settler who is not well and depends on Home Office make an application for her kid? I think not depend on Home Office, but you depend on the welfare system to survive. Can you make an application for your kids to join you?
So when it comes to application for your children to join you, remember that there are certain requirements under the immigration rules. So if you're making the application under Appendix EU, then you would have to show that those children were born to you before 31st December 2020. So they were your family members before that date. Unless you've just had the baby, obviously, then you would have some sort of, should I say, eligibility under the Appendix EU. If you are not able to show that they were your children before 31st December 2020, and you are saying that they've been in your country, Ghana, for the past, let's say, 10 years, because that's when you came to the UK, then you would have to be able to make an application under Appendix FM, which is our usual route of making applications for children to join their parents or their guardians here in the UK. Or if you are saying that you have indefinite leave to remain, you can also make the application under paragraph 297, which shows that you have settlement here in the UK. You would also want your child to come and join you here in the UK, but you must be able to show maintenance. So, one way of showing maintenance is the fact that you either receive an income and therefore you can show that you'll be able to maintain the child when the child comes, or you have savings of an amount which is more than the income support rate that they give to family members in the UK. And therefore, when the child comes, they will be maintained by yourself. So the maintenance requirement includes your income. If you are receiving benefits, yes, it's your income, but it will not be able to suffice if there's another person coming to join you here in the UK. So you need some extra income to show that, of course, when this child or these children join you, you can also maintain them when they come. And that is usually applications that are done under paragraph 297 or under appendix FM of the immigration rules. If it's under Appendix EU, then you don't have to show any maintenance whatsoever.
Still live on BWTV, and we're bringing you the community and the law this afternoon. We've looked at whether we can apply for our children to join us in the UK if we cannot afford to pay the application fees. Lawyer Eunice Champon is our resource person and guest. She is a solicitor at BWF Solicitors and a partner of the firm. She is on hand to answer your questions as people have been doing. Now let's pick up another one and put it to Laura Champon. Jennifer is asking, can an overstayer get married to a skilled worker in the country?
I mean, when it comes to marriage, who decides for who you get married to? Marriage is a matter of personal choice, and if you want to get married to somebody, why not? If you are saying you want to be able to find out if marrying somebody who is a skilled worker will help you in obtaining immigration status in the UK, then of course that is a different question altogether. So, in terms of marriage, of course, you can get married to whoever it so pleases. If the person is a skilled worker, we'll need to know more information about what routes they are on and how you can apply as a dependent. So, yes, you can get married to a skilled worker if you're an overstayer, but in terms of immigration status, it may mean that we need to get more information because under our immigration rules, usually it's somebody who has settled status who can then afford to make an application for a partner. And then there are also other requirements such as insurmountable obstacles and the rest that you would have to look at in terms of making the application as an overstayer. So it's not just on the basis of your marriage. So yes, we will need more information if you are making it on the basis that you want to gain immigration status.
You can contact BWF Solicitors on 0208 493 7340. And you can also visit them on the fourth floor of Vienna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. We're still picking your calls. You are also welcome to send your text to the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Can you come on the care worker route and your employer license? Oh, okay. Sorry. You came on the care worker route 3 years and your employer license was revoked. And for that, you couldn't pay your required taxes on your NI, but your right to work is still active. In case I get a new COS, can I apply for indefinite leave to remain after the completion of the new certificate of sponsorship, Lawyer?
So, in terms of somebody who's already been here 3 years, obviously it's showing that his right to work is still very much intact, and so he's not so much bothered. But I'm guessing that he needs a new COS because he needs to make up for the 5 years. So if you were granted 3 years, just because the Home Office hasn't sent you a notice of cancellation doesn't mean that they will never send you a notice of cancellation. Here you have your sponsor or your employer's license which has been revoked. So at any point in time, the Home Office can send you a notice of cancellation of your visa because the employer on which you are relying on ceases to operate as a sponsor. So it's important that you make sure that you switch or you find alternative routes to apply on before that cancellation notice is sent to you with the 60 days. Don't assume that it's going to be valid forever. It's not the case. So once you are able to get another company who is willing to sponsor you for the rest of the time that is due, then definitely go with that sponsor in terms of switching to a new employer. And then after the 5 years has come to an end, hopefully you can apply for settlement. We look to see what Parliament will be coming up with in April. There've been so many debates about the settlement
Hello.
rules that will be coming, and as of last week, there were more discussions in parliaments, and different MPs were sitting to obviously make their constituents' concerns known before the government brings in these new settlement rules. So hopefully, it wouldn't change very much for those who are already here in the UK. But let's hope and see.
Well, Alice, we have the lines active, and we've got a caller on the line. The lines are on now: 0208 493 7345. Hello.
Hello, good evening.
Good evening. Linus, can you hear her?
Yeah, I can
Yes,
hear.
I can.
Oh, sorry.
Oh, okay. All right. Please go ahead.
Please, good evening. My question is, my brother is in this country, but he's an overstayer, and he has gotten a partner who is on the school working visa route, and the lady is pregnant now. So we want to know if after lady finish giving birth, can my brother switch to the school working visa and be okay in the immigration status or what? That's what I want to know.
Linus.
Yes, I think so. Obviously, it carries on from the question you previously asked online. So, in a case where your brother is looking to obtain immigration status, the immigration rules are very clear as to as somebody who is an overstayer. So in his case, he has no leave and he wants to make an application to remain in the UK. Usually, that will be a human rights application. And in human rights application, you are looking to rely on your spouse or your child. In this case, where the spouse is not somebody who is settled or somebody who is British, they will not be seen to be a spouse under Appendix FM who is eligible to sponsor this brother of yours. But if you are saying that the child she's going to have is going to have some form of settlement, so either the child is a British citizen, the child is has got indefinite leave to remain, or the child has lived in the UK for a continuous period of 7 years, then the application can be made on the basis that he has a child who is settled or a child who is British and he's making that application on that basis. However, in this case, I'm sure the child is neither going to be a British citizen or a child who is settled in the UK. And so the child will also not be an eligible or qualifying child under the immigration rules. In this case, he will not be able to rely on both the spouse and the child in terms of making an application under the immigration rules. And so, if he needs further advice, let him book a consultation with us.
Okay.
All right.
Okay.
Well, dear sister,
Thank you
I,
very
I
much.
I think I would insist that you heed to the advice. Contact BWF solicitors for further conversation,
Oh,
okay?
all right. Thank you so much. Thank
Thank
you,
you.
Lawyer.
Thank you as
Yes,
well.
thank you.
God bless you. 0208493735. Gifty has a British child from a previous relationship. This is Citizen Kweju. And he's saying the British child is under 18. Based on this child, she was granted leave to remain in the UK. She later married Kofi under Ghanaian customary law, and both parties were represented by family members and friends. As Gifty is not Ghanaian, can her husband apply under the family route based on their current marital relationship, her residence in the UK, and her British child? So he's giving three um, scenarios of immigration status lawyer.
Yes, he says that Gifty was able to apply for leave to remain based on this child. So I'm assuming that Gifty hasn't got indefinite leave to remain. So that's my assumption, first of all.
Mm.
And then the child is the one that has British citizenship. And so the child is a qualifying child under our immigration rules. Now, Gifty is married to Kofi, and Kofi obviously does not have any immigration status. He wants to find out whether he can make an application based on his marriage or based on the British child. When you look at the immigration rules, like I was saying to this previous caller, usually they want to find out if your partner is an eligible partner in the first place. So either the partner is British or has some form of settlement here in the UK. They will be considered to be eligible partner, and you can make the application on that basis. Here, like I was explaining to the lady, we have Kofi who hasn't got an immigration status, and so he's married to Gifty now, and he wants to be able to make an application on the basis of their child. Now we know that the child is his stepchild, and therefore, under the immigration rules, if he's married to Gifty, this child is also his child due to the marriage that they have contracted between the two of them. And it's important to know that because he's now part of the family, he has to be able to show that he's playing an active role in the child's life. And so, under the parent applications, they always say you have to show that it will be unreasonable for the child to leave the UK. And in this case, the child is a British citizen, and based on the fact that they have previously granted the mother leave to remain on that basis, it will be unreasonable for the child to leave the UK, and therefore the father, who is the stepfather, can also make an application on the basis that he is a stepfather to this child and would like to remain in the UK.
Well, we moving. I think we'll pick one very last one from the platform, and then we go back to our nugget and discussion again. Mami Tando is asking, please, can a main applicant bring her kids if the dependent is refusing to give their consent?
I mean, if the main applicant wants to bring her kids to the UK, why would it matter if the dependent is not in agreement to it? Unless you're saying that your dependent is the husband. So, for instance, the main applicant is the mother, the dependent is the father, but unfortunately, he's not consenting to bringing the child or bringing the children to the UK. In that case, you would have to make the application on the basis that the father is here. Unfortunately, you're unable to get him to sign the consent form for the children's application, but he is here, he has valid leave to remain here in the UK, and you are making the application that you are both here in the UK and you like to bring your children to the UK. It's important for the dependent to also know that obviously when it comes to making such an application, they can be contacted by the Home Office as well. So you should bear that in mind.
Well, thank you very much, Laya Eunice. And to you folks out there, I'm going to ask my question again. It involves two people who got married. One person was not available at the marriage ceremony but got a representation. An application has been put in, and this person has been refused. And we need to advise that. So let me tell you and put it in a very good context for you. Mary and Joseph, the ones I'm talking about, they got married in Ghana in June 2025. They registered their marriage in court and they were issued with a Ghanaian Ordinance Marriage Certificate dated the 20th of June 2025. Mary, who is in the UK, could not travel to Ghana for her wedding, but she got her uncle to represent her at the marriage registration. Down the line, 15th of January 2026, the husband, who was there at the marriage and the registration in Ghana, submitted a visa application to join his wife, Mary, in the UK. 2 weeks later, more or less, Joseph received a refusal decision from the Home Office. The only reason for the refusal was that his marriage was not valid because Joseph was not present during the marriage. So I am asking you to advise Joseph. Are you going to tell him that he should appeal because the case worker did not apply the rules correctly? Are you going to tell him that he should not appeal because the case worker applied the rules correctly? So it's either A or B, one or two. What's your answer? Keep them coming through. I'm going to take a quick break, run you through my social media handles, and when we come back, I'll pick your answers. Okay, well, we're back, and I am looking forward to your answers. What did you advise Joseph and Mary? Engineer Samuel Mensah says Joseph should appeal that decision. So that's number one. Who else is here? Let's see. Now, Kwame, you should appeal. Number one. Okay, thank you, Nana Kwame. Next, we have Citizen Kwajo. Number one, he should appeal. Thank you, Citizen Kwajo. Next, we have Esther Saki. Esther Saki. No. It must be a wrong answer. Maybe you're watching a different show, maybe. Well, we gloss over that. And Janet Kubi says is number one. He should appeal because the caseworker did not apply the rules correctly. Next one here is from Kufisei. Kufisei says he should appeal because the caseworker did not apply the rules correctly. Elizabeth Aite, Kofi should ignore it. Forget about it, Kofi. You should not appeal because the caseworker applied the rules correctly. We have Yao Banahene also saying the same, that he should not appeal because the caseworker applied the rules correctly. Kwajo say, again, we have another person saying it's number two, he should not apply because the caseworker applied the rules correctly. Henry Amwa says number one, Joseph should appeal because the caseworker did not apply the rules correctly. Mary Tortu, he should appeal. Thank you, Mary. Next one, Prince Yabua also saying he should appeal. We take the last one. Okay, well, let me go to lawyer. Um, Initially, I wanted to put this to you and run it by you, lawyer, whether I should tell Joseph to appeal because the caseworker did not apply the rules correctly, or he should forget it because the caseworker actually applied the rules correctly. What would be the correct advice, lawyer?
So if you look at the question critically, it says that Mary and Joseph married in Ghana, and they had their marriage conducted via a Ghanaian ordinance marriage. And the certificate was granted dated 20th of June 2025. So there's a difference between an ordinance marriage and a customary marriage.
Hmm.
The customary marriage is usually done by family members, and then they obviously stand in for you and register the marriage at the um, relevant municipal assembly. A marriage which is done by ordinance requires both parties to be present at the registry once the ceremony is taking place.
Mhm.
So, if you are saying that your marriage was conducted by ordinance, then the requirement is that both the husband and wife should have been present at the registry before the marriage took place. If one of the couple was not present, then of course the ordinance marriage could not have gone on because both parties need to be present for that ceremony. So I can see where people missed that and chose answer one. So the advice would be that Mr. Joseph will have to leave that um, application because unfortunately he did not present the right marriage certificate, and therefore the caseworker made the right decision.
Lawyer, I take it. But let me go back to the question and put up some argument if
Yes.
I could be right. Now, we have been told, I think the very first update we had before the nugget, if we could put that on the screen, I will make my argument from there. Under, no, not this one. Yes. Your customary marriage contracted in Ghana through family members, that is proxy, is valid under UK law if it followed Ghanaian law and procedure. Now, based on this one, we know that Ghanaian customary marriage could be contracted, and at a later date, they could send it to the assembly for it to be registered.
Mm.
Okay. The last but one paragraph of this Awuku and Secretary of State for Home Department case says that always follow, or the advice we gave was that always follow Ghanaian law by asking family members to register the marriage at the marriage registry or the metropolitan or district assembly. Now, fast forward to Joseph and Mary, their
Mm.
case. It says that they married in Ghana. It didn't tell us what marriage it was, but I can assume that if they married in Ghana, then obviously they did the customary and later on sent it to court for registration. Could that not be the case?
So there is the possibility that they could have conducted a customary marriage and a registry marriage because the scenario clearly states that it was done at the registry by Ghanaian ordinance. So we know that in this case, it's referring to an ordinance which took place at a registry. But most people do both anyway. I know that those that usually get married in Ghana will usually have the traditional marriage, which some will refer to as the engagement, and then you have the registry marriage as well. So if for any reason you are saying that you did have the customary marriage and then the registry marriage, then it is important that you get your family members to register the customary marriage as soon as possible. Because in this scenario, because reference has been made to the marriage by ordinance, that means that both couple were present at the ceremony. But if they did do the customary marriage or the traditional marriage beforehand, then it would be advisable for them to go and have that registered and the right documentation prepared in terms of the customary marriage.
Okay. So, on the face of this question and the facts in there, the answer is two, yes. But if they would want to prove to the Home Office or the caseworker that it probably wasn't that it wasn't the situation, they had a customary, but later on got the uncle to represent Mary at the registry for the registration, then they could provide some evidence to show that that is what happened. Would that be okay?
Yes, of course. If you are able to provide evidence that the customary marriage took place before this registry ceremony, then yes, you can provide evidence in your further application that this was the case. Unfortunately, you didn't know that you could present the customary marriage certificate. And now that you've sought legal advice, you now know that you can present your customary marriage certificate if it has followed the due process in your country. It is also going to be seen to be valid here in the UK.
Okay, well, those of you who chose one, I was trying to see if I can wrestle the answer in your favor, but that's not it because the facts before us is that Joseph should not appeal because the appeal will be dismissed. Mary was represented by a proxy at her marriage to Joseph. Therefore, the marriage should have been registered under customary marriage rules. Remember, under the UK immigration rules, one of the requirements for a spousal visa is the validity of the relationship, as we got to know earlier on from paragraph RWP 4.1 of Appendix Relationship with Partner. So, where the relationship is based on marriage, the rules stipulate that if an applicant and the partner are married or in a civil partnership, the marriage or civil partnership must be recognized by law in the country in which it took place. This is me talking law, properly like a lawyer, but I'm not. Right? Courtesy BWF solicitors, I'm so empowered. Like we want you to be so empowered. And that's the reason for this program. This afternoon, we have looked at a very interesting topic. And what we sought to find answers to was the fact that we wanted to know if we could apply for our children to join us in the UK if we could not afford to pay the application fee. Lawyer, what was the answer in summary?
So we said yes, you could apply for fee waiver if you are a parent who cannot afford the fees, or you are in a situation where you find yourself destitute, or it could be that if you were to pay the fees, you would become destitute and would not be able to afford your essential needs. Or there might be compelling and compassionate circumstances, in which case you cannot afford to pay the home office fees and the immigration health surcharge. You have to prove that you truly cannot afford the home office fees by presenting evidence of your bank statements which show your income and expenses, as well as any other proof of income and your expenditure. So if you are paying for other expenses, you can bring evidence of your bills. And also, if you are working, you can provide evidence of your pay slips to show the income you are receiving. If you are of course, self-employed, you will show evidence of your self-employment, and that will go a long way to also help the caseworker looking at your case know that indeed you are not able to afford both the immigration surcharge and the application fee for the child you are bringing over or the children you want to bring over. Know that this will not obviously affect you meeting other eligibility requirements as well. And so, when it comes to meeting the eligibility requirements for bringing a child to the UK, those will also be looked at separately. So, yes, you can apply for fee waiver application in regards to a child or children who you would want to join you here in the UK.
Word to the wise is always enough. But I want to say that when you have heard this, remember that you can trust BWF solicitors, one, to empower you and also to give you the right piece of advice. Let's all together say thank you to Lawyer Eunice Achampong for her time this afternoon, a share of knowledge, and of course, the feeling that we're so empowered by what she's told us and the answers she's giving. And one advice she's giving is that, come, let's have a conversation. Talk to BWF solicitors, 0208 493 7340. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Those of you in Ghana, you can visit and contact our office number on the number, so to speak, 055 589 5959. In emergency situations, the UK number 077 127 61884. Our website, bwfsolicitors.com, and our social media handles at BWF Solicitors, Facebook, YouTube, and all of them. We have had another wonderful time, and I believe that we are all pumped up for another edition same time next week. To you out there, thank you very much. The invitation is extended to you. Thank you very much, Lawyer Eunice, for your time. Thank you, BWF Solicitors, for giving us this opportunity. And to my production team, Shilankra, Padmododu, and Professor Ade, I want to say thank you so very much. And together, let's welcome Lena Asma into the fold. And if you have any feedback to give us, don't hesitate to do that. We'll bring it up same time next week when we bring you another edition of The Community and the Law. Good evening.